this evening's event of the British Chamber of Commerce in Thailand. My name is Stephen Frost. I'm a director of the Chamber and I'm chairman of the Legal and Taxation Subcommittee. Our event this evening concerns Thai wills and also the issue of foreign ownership of property in Thailand. Our distinguished speaker to my left is Gaff Khan, who is Director of Legal Services at Orion Investigations in Bangkok. He practiced as a lawyer in the UK for 27 years. He set up in the UK and managed his own successful legal firm and held a number of departmental head positions in various legal disciplines. He has appeared as an advocate in many tribunals in the UK and obtained a certificate of higher rights of audience in criminal law in the UK before moving to Thailand with his family in 2015. Gaff manages the lawyers in Orion Investigations, reports to clients with regular updates on the progress of their cases, and is responsible for ongoing development and also training of the legal team at Orion. Before we commence the event, can I ask you please all to switch off your mobile phones so there's no disruption to the speaker's presentation? And can we have a nice warm British Chamber welcome for our guest speaker tonight?
Thank you for that kind introduction, ladies and gentlemen. I'm going to try and do what I can to make a very dry subject or subjects as sexy as I possibly can. Can I just make a few preliminary remarks about it? I mean, when you look at a subject like inheritance law or property law, those of you who are lawyers will know what I'm talking about. We're talking about a vast ocean of information. Of course, I may be addressing some lawyers in the audience, but hopefully most of you are here with an interest in the subject rather than here as lawyers to hear another lawyer speak about it. So what I'm going to try and do is to pick out the bones of the law and the bones which I think are going to be relevant to the audience in front of me, mainly addressed at, and I apologise to any Thai nationals here, but it's aimed mainly at the expat community, the non-Thai nationals, the aliens, call us what you will. That's the audience at which I'm pitching this particular seminar. Okay, so without further ado, let's start with the inheritance laws and in particular wills, whether you need one, why you should have one, and the pitfalls of not having one. Like most developed legal systems, Thailand has provision for inheritance should you be in a position where you unfortunately die without making a will. As is the case with most law in this area, it's the Thai Civil and Commercial Code that covers it. And it's in line pretty much with what most of you will be familiar with coming from Western countries. There is an order in which loved ones inherit where you don't have a will. So looking at the order under the Thai Civil Code, the first class of parties that inherit if you don't make a will are descendants. So that's children, grandchildren, and so on, direct descendants. The second class are parents. The third class, brothers and sisters of the full blood. Fourth, brothers and sisters of the half blood. Grandparents, if they still happen to be alive. Uncles and aunts. And then the provision is made for the surviving spouse. Now, the surviving spouse, if there is a spouse, also has other rights outside the inheritance laws, essentially, without going into too much matrimonial law, automatically inherits jointly owned property, half of it. So jointly owned property is property that's acquired during the course of a marriage. So half of that property will automatically pass to the spouse, and we're dealing then with the rest of the estates. And as in most jurisdictions, if there are survivors in class 1, then they inherit. You don't go to class 2. So if there are descendants, parents don't get a look in. If there are no descendants, but there are parents, brothers and sisters don't get a look in, and so on. So you go down the class system. So it's there to protect those who haven't gone to the trouble of organising their affairs, and to that extent there's not a great deal to worry about, you would think. But a lot of the horror stories that you hear as lawyers, and I have got two quite experienced guys who deal with inheritance disputes, the vast majority of disputes arise in situations where there is no valid will, because all sorts of issues arise. So you've got a fairly codified system of law. The other thing that I think in the West a lot of people worry about when they think about wills is the good old taxman. How do we minimise tax? How do we get around paying the taxman X amount of dollars or pounds from the hard-earned cash that and the capital that we've built over the years? Not a huge problem in Thailand, unless you're a very, very wealthy person, because the threshold for inheritance tax, and let me just check my notes to make sure I've got it correct, is 100 million baht. So unless you're in a category of millionaire and you have an estate worth over 100 million baht, taxation is not your primary reason for looking at estate planning and wills. But there are important things that the general law isn't going to cover. Things like if you have children, infant children, who may be left around at your death, who the legal guardian is going to be. These days, in the days of modern travel, it's quite possible for two parents to die in a common accident. Who's going to look after the kids? So appointment of guardians is a very important issue and something that should be at the forefront of the mind of those people who have younger children. And that's something, if they want grandchildren to inherit as well, something perhaps to think about. The other issue is the choice of executor. An executor in a will is somebody who takes on a very, very important role. This is the person you are trusting with your estate. This is the person who's going to carry out your wishes in accordance with the law and in accordance with your direct wishes. So appointment of executor is something that you can actually allow for in a will. In an intestacy situation, that's not going to happen. And what tends to happen is there tends to be a scramble between the surviving heirs as to who's going to take on that responsibility. And it can lead to conflict. Okay, conflict perhaps post your death, it's not really going to concern you that much, but if you want the peace of mind of knowing, then choice of executors is quite an important thing. Now, generally speaking, in most jurisdictions in the West, you would also appoint trustees, particularly if there are children or there are people under disability that you want to inherit your property. And usually the executor and the trustee will be one and the same entity. It might be a person, it might be a legal firm, it might be an accountancy firm, it might be a bank, whoever it is. And there are statutory rules that govern how trustees behave. Unfortunately, in Thailand, the law of trust does not exist. There is no trust in Thailand. It's null and void if you put it into a will. So, what do you do in terms of looking after people under disability or children who may be minors at the time of your death? Well, Thai law prescribes that you can appoint somebody called a controller, and as soon as you mention that word, it raises all sorts of alarms. The controller essentially is is a guardian who looks after the finances of somebody under a disability or a child. There are laws that govern how they behave, so it's not as bad as it sounds. It's the term that people don't like. But you can't actually set up a trust. What you essentially do is you say, I appoint this person to be the controller in relation to the assets which I leave to my children, and hopefully it's somebody that you can trust. Choice of executors, again, there are a number of choices, but an important issue is that under Thai law, a beneficiary cannot be an executor and vice versa. Now, that's different in many Western jurisdictions where the primary beneficiary, usually in the case of a married couple, the spouses will appoint each other as executors in the first instance, leaving out anybody else, and then in the event of common death may then go on to choose either a family member or a lawyer or an accountant or somebody that they can trust to carry that out. So in Thailand it becomes quite an important issue. Because they cannot benefit under the will, who do you appoint? What you're essentially doing is putting a huge responsibility on somebody and saying, I'd like you to administer my estate for me in accordance with my wishes, but you ain't going to get paid for it. Yes, you can claim your expenses, that's perfectly legitimate, but I'm not going to give you $20,000, $30,000, $40,000 for doing it. So it's quite an onerous position. That's why a lot of non-Thai nationals will tend to use professional executors. They'll tend to use the person who drafts the will. That's not me giving a plug to my company, but that tends to be what happens because there's a number of reasons why. A, because you're dealing with somebody who's experienced. B, and very importantly, companies live on, they don't die. People do. So if you appoint an executor who is a person who happens to die before you, you've got a problem all over again. If it's a legal entity or a company, that company lives on, and it may not be the person who drafted your will, but somebody will be sat in their shoes at the time of your death who can take on the role. Of course, you've got the experience there, and you've also got protection not only from the law, but also professional ethics that comes with being a professional. So you've got somebody there who knows what they're doing and is going to carry your wishes to the letter. And I think, certainly from what the lawyers tell me in my team, it takes a lot of sting out of the situation. So if you've got two parties, two brothers at loggerheads or two siblings at loggerheads, a professional executor tends to calm the situation down and says, look, this is what it says, here it is, it's in black and white, that was your father's intention, let's not fall out about it, and it does tend to work. Of course, professionals charge, and you can't hide that fact, but professionals who are executors, by and large, cost considerably less than professionals who are engaged by executors who are lost and don't know what to do. So if you've got a friend who suddenly finds himself in the position of executor, hasn't got a clue how to go about things, he goes to his nearest lawyer and says help, and produces this raft of documentation and says, can you get on with that for me? That actually costs more money than if the professional is an executor. So a little bit of a plug for the profession there, but I think it's a point well worth making, specifically because you cannot be an executor and a beneficiary under Thai law. So we've talked about the whys and wherefores of making a will, and I think it's an international question, it's not just a Thai question. A lot of people ask me, well, why do I need a will? My simple answer is peace of mind. You know where you stand, the loved ones around you generally, because you've told them, will know where you stand, and you know that after your demise everything will run hopefully smoothly without the battles ensuing. So that's, as I say, a very, very quick helicopter overview of wills, of inheritance law, and there isn't a great deal more that I want to say about that. I'm sure there'll be questions afterwards which I'll deal with. a lot of the other issues related to inheritance deals with property and property inheritance, and I'm going to deal with that under the property section. Okay, moving on to land ownership for foreign nationals. Well, let's start with the golden rule in Thailand. The golden rule as a non-Thai citizen is that you cannot own land. Full stop. There is a very minor exception to that, but not worth really mentioning other than in passing. If you have 40 million baht to spare and you happen to live in a particular area that's been nominated, you might get one rai of land for residential purposes, but it's only for your lifetime, and then it goes. So, very, very rare exception, and I don't know personally, I'll be corrected by any lawyers in the room if there are any, but I don't know of anybody who's actually taken advantage of that particular exception to the rule. So generally speaking, you can't own land. Dealing with then the sort of types of property that you would generally associate with foreign nationals buying in Thailand and getting involved with in Thailand, let's start with the most popular. The most popular is a condominium. Now, okay, there's a lot of debate about what is a condominium, what's an apartment, what's a flat. As a UK lawyer, I don't distinguish. A flat's an apartment's a condominium. Condominium's an American word, flat's an English word, apartment is both English and American. It all means the same thing. It means one of those high-rised with a block in it, okay? And it's always leasehold in those jurisdictions. The odd concept in Thailand is you can have a condominium on floor 32, but it's a freehold, which is counterintuitive because usually when you think of freehold, it's attached to the land, not somewhere up in the sky. But a condominium is in fact freehold, or most condominiums will be freehold. Now, looking at condominiums versus apartments, what's the difference? Well, if you look at one building compared to another, there's no way you can tell. So the only way to actually find out is to ask the question. If you're buying, go to a juristic person, or if you're going 9 times out of 10, you'll be buying through an agent. The agent will know, if not, they will inquire. And the question is quite simply, is this a condominium registered under the Condominium Act? If it is, it's a condominium. If it isn't, then it's not a condominium, it's an apartment, or whatever else you want to call it. Now, why is a condominium preferable? Well, let's start with the obvious. First of all, you can own it outright. Secondly, it is actually covered, the administration of the apartment block, or the condominium block I should say, you see how the words slip between one and the other, is governed by a very robust Act of Parliament, the Condominium Act. And the Condominium Act covers all aspects of running that particular complex, right down to how it's managed, who takes care of the common parts, what your rights are as a co-owner, what you can expect from the committee, what can you expect from the manager, and so on. And there are sanctions, legal sanctions against people who take on management roles within the condominium setup. So it's what most of us who come from Western jurisdictions would understand as being quite normal. When you buy a flat in London, there's a management company, you pay a service charge, they take care of the building, they take care of their insurance, they take care of the common parts, and there's law governing what they do to make sure they do the job properly. That's what a condominium is here. It's exactly the same as we would understand in the West. And I have to say, having on our books a number of juristic offices, the Condominium Act is very comprehensive and is a very good piece of legislation. Okay, well, apartments. Apartments are, by definition, flats, apartments that are not registered under the Condominium Act. That's not to say that you have absolutely no protection whatsoever. That would be wrong to suggest to you, but you certainly don't have the cover of the Condominium Act. And therefore, my advice to anybody who is going to buy a condominium/apartment, condominium would be my choice, and that's what you would go for. And in fact, if you're borrowing money, then it's something that that the bank is going to be looking at as well, because they obviously prefer something that's properly regulated under the law. Somebody asked me about about loans, and perhaps it's a good time to mention that. It's very, very difficult for a non-Thai national to get a loan to buy a condominium in Thailand. It's a policy amongst the banks. I don't know why, but there it is. That's even for people who've lived here for some time. The notable exception to that is UOB Bank, and I'm not on any commission here. They do tend to lend foreigners, but they are quite expensive. 6% arrangement fee is fairly typical for UOB Bank, and they tend to channel the mortgage through Singapore and other jurisdictions, although you will get the money in baht coming out of one of their branches here in Bangkok and elsewhere. Now, again, what a lot of people don't realise is that there are qualifications required for you to actually purchase even a condo. People think, well, you know, I can come here on a tourist visa and I can buy a condo and that's the end of it. It doesn't quite work like that. There's, under the civil code, there are restrictions on who can buy, and I'm just going to run through those with you. The people who are permitted to purchase, this is where the word alien comes in, expat, non-Thai, call us what you will. Aliens permitted to have residence in the kingdom under the immigration law, so you can buy. Aliens permitted to enter the kingdom under the investment promotion law. Again, that's if you're investing a considerable amount of money. Juristic persons and aliens under the announcement of national executive. Again, that tends to be a specific group and it applies to businesses. And this is where a lot of expats qualify. Aliens or juristic persons regarded by law as aliens who have brought in foreign currency into the kingdom or withdraw money from a Thai baht account. So a lot of expats will qualify under that ground, so they don't have to then have a work permit and live here, but they can bring in foreign currency in order to purchase an apartment or a flat or a condo, and that qualification is there. So it's not quite as simple as somebody coming in on a 30-day tourist visa and saying, well, I'm going to put down a deposit on a condo. So there are qualifications that are required. Dealing with the inheritance aspect of, let's deal with condos and apartments, they're pretty much the same. If somebody qualifies under those regulations, so you have a child, for example, who you want to leave the condo to, and they have a right to remain in Thailand, and they have a work permit and so on, then there's no real issue. The issue does arise, however, when, and as happens with a lot of expats who have children abroad, where they want to leave to a son or daughter who lives in, let's say, Germany or France or England. It's not as easy as it looks. Yes, they can inherit under your will, but what they can't do is actually retain the property. What they have to do is they have to either come and live in it, which is not always convenient, or they have to sell it, and they have a year in which to do so. And if they can't do it within a year, then the government will take over that role at a cost of 5% of value and do it for you. So it's not quite as straightforward, even though you do own the property outright. There is a quota, most of you will know, and it's on a par with company ownership. In a complex, only 49% of the units can be sold to non-Thai nationals. 51% must be retained for purchase by Thai nationals. So that's something, again, well worth looking at when you're looking at a new complex, or when you're looking, particularly when you're looking at a complex that's established. It's a question that's worth asking. But again, because of the Condo Act, because of the rigidity of it, because it's a very good piece of legislation, agents will generally be told, no, we've got no more units for sale because we're up to our 49% quota. So you might like a building but be told that no, you can't actually buy there because the quota has been met. Okay, moving on to ownership of land and homes, houses, if you like. And again, quite a popular thing for people who choose to retire here. People who've made their home here for a decade and longer, often married here, often with kids who've grown up here, who suddenly want to either build or buy a house in which to retire. And this is an area which I'm sure all of you have heard all the horror stories, and most of them are true. Now, in terms of the classic situation where somebody wants to buy a plot of land in Phuket, in Hua Hin, in Pattaya, and build that dream villa or home in which to retire. Let's talk about that first, because that's predominantly where a lot of my ex-black clients happen to be, in that region of wanting to do that and then protect themselves in the future. Well, the golden rule is you, Mr. Client, Mr. non-Thai national client, can't actually own any land. So what do? Well, in the vast majority of cases, that will already have been taken care of. It's usually a spouse or a partner. Okay, don't worry about that. I'm married, I'm happily married, and my wife's going to buy the land. Fine, no problem. That's perfectly legitimate. When you come to register that land as a spouse, you will sign a declaration to say, this land belongs to my spouse 100% and I have no claim over it, even if you paid for it, even if the money has come from your account overseas, because that would be to dilute the law to allow you to have any propriety rights over it. And you actually sign a declaration to that effect, so you can't go back later and say, I didn't know what I was doing. That has a consequence when it comes to a breakdown of a relationship, or a breakdown of marriage in particular under matrimonial law, because by virtue of signing that declaration, you are signing a declaration to say that the land is not joint property, but is the personal property of my spouse. Therefore, even in a matrimonial court, you cannot then argue, well, hang on a minute, it's jointly owned property, so I deserve half of it. The answer is no, you signed a declaration, it doesn't belong to you. So that's the land aspect of it. Okay, we're now going to build our dream villa. So how do we protect ourselves? Well, there are two ways of doing it. One is better than the other. One covers new buildings, others covers existing buildings and new buildings. Let's talk about the new buildings and let's talk about the safest route. There is a route under the Thai Civil Code whereby you can separate the land from the building that goes onto the land. So your villa, your pool, your pear tree, your orange tree, everything else on the land, you can separate the two out legally. And you can do that by entering in something called a contract of superficies. Doesn't sound very pleasant, does it? But that's what it's called, the contract of superficies. And it's a way of protecting your investment in a property, not simply in the case of a marriage breaking down or a relationship breaking down, but also to cover you in the event of death, death of a partner. Because by owning the land, by owning the property, on the land, you are fixed to the land. It's there for everybody to see on the Chenote at the land registry, land department, and any buyer coming along can see, oh, there's a right of superficies. Therefore, you're protected. And you're protected to not only during your lifetime, but beyond your lifetime, because you can pass on the superficies contract by inheritance. Now, you could do it one of two ways, and it depends on the particular circumstances as to which way you might want to go. You can actually do a finite fixed period up to a maximum of 30 years, or you can go for lifetime of the person who has the benefit of the contract. It is a contract, bear that in mind, between the landowner, usually the spouse or partner, and the superficiary, the person who has the benefit and owns the land. So it's a contract between two parties, but unlike the other aspect that I'm going to come to, which is a lesser protection, it does run with the land. So essentially, whilst the building is intact upon the land, your right is protected, and you can pass it on under the terms of your will. It would be passed on in testacy in the normal way as well. So that is probably the best way to protect your investment when you are spending a considerable amount of your hard-earned cash on building that villa of your dreams. So that's a superficie contract. The other, I should add that the superficie contract has one drawback, and that is that it can only be registered whilst the property is in the course of construction. Once you move into the property and you actually live there, it's no longer available to you. So what about, and I know I was talking to a member of the audience who sat at the back there, what about somebody who falls in love with a house, or whose wife falls in love with a house that they want to buy? Well, the best you're really going to get is the second category of protection, which is called a usufruct contract. And a usufruct contract is again a contract between two parties, but essentially it does not in any way confer ownership of the property or the building to the person with the benefits of the usufruct. What it essentially does is gives you a right of occupation. And once again, you can do it for a fixed period of up to 30 years, or you can do it for life. And again, the difference between that and the reason it's not as secure is because it's a contract that doesn't run with the land, it actually dies with the person who has the benefit of it. So it's a contract that comes to an end if you have the benefits of that land. So those are the two ways, and those are the two areas where I tend to be giving most advice, because that's the kind of area where certainly amongst the middle-aged and above who are been here for years, who are retiring, who quite rightly have chosen a lovely spot by the sea where they want to build, that's the kind of area. And these are the areas in which you hear horror stories. Let me tell you one horror story, and all I can say is that it happened in Phuket, and that probably won't surprise you, but here's just an example of what can and does go wrong. This was a particular case where we inherited it at the dispute stage. It was done in a correct manner. The correct advice was given, and a superficies contract was registered, and the land belonged to the spouse, and the buildings belonged to the expat investor, the other spouse, of course. And then things went awry, and unfortunately the Thai spouse died, predeceased. You think, well, okay, from what we've just been told, that's about as safe as you're going to get. Unfortunately, this particular idyllic dwelling just off the beach was set in a large plot of land, and what was missing from the usufruct contract was a right of way from the road to the house. The family of the deceased spouse was able to get a declaration from the court saying he had no right of entry. And about 3 to 4 million baht payoff later, we managed to acquire right of way in order to get back to where we were. And unfortunately, the lawyer concerned, although he thought he'd done a great job, had missed that little point, but there was no professional indemnity insurance to go after the lawyer, so it was a very costly lesson to learn. But that's the sort of thing, the sort of detail you've got to look at. And what some companies in this region do that deal with this kind of stuff is they'll marry up a superficies contract with a lease. I personally don't see the reason for doing it, because I think most land departments find it confusing enough, particularly if you're in the provinces, that a foreign person should want a superficies contract, and you do get a lot of resistance to it, I'll be honest with you, in the suburbs. But throw into that a lease, and the land registrar jumping up and down saying, what is it? What do you want? Do you want a lease, or do you want this, or which one do you want, and why do you want both? And so it gets very confusing. As long as you cover the key points, the right of way and so on, the superficies contract is perfectly sufficient and, as I say, inheritable. Okay, so moving on to other types of contract you can have. Well, you can have a lease in land. And again, this is something that people have done in the past. They've got a Thai friend who owns a piece of land, and then they've built something on it and they've taken a lease up to a maximum of 30 years, which is allowable. Now, there's a lot of hype out there. There's a lot of, particularly in the holiday resorts, that you come across, oh, we'll give you a 30-year lease and we'll extend it for 60 years and then 90 years and so on. And I've heard as long as 90 years. It's nonsense. It's absolute nonsense. The only safe bet is that you're going to get a 30-year lease. Yes, you can build in an option to renew the lease for up to a secondary period of 30 years, which gives you 60 years. But that is certainly not enforceable if there's a change of ownership in the land. And secondly, as far as I'm aware, it's never been tested in court. The only sure thing is that you can get up to 30 years. So when you read about off-plan developments where they'll give you a 30-year contract with 2 terms of renewal up to 90 years, it's probably a scam. So you've got to be very, very careful of reading that and looking at it. The only sure bet is you're going to get a 30-year lease, maximum 30 years. The problem in Thailand as well is that there is no leasehold law. There's no specific law relating to lease of land. So it's covered under contract of hire. And there are rules and regulations that cover a contract of hire, but it's no different from hiring a car to hiring a piece of land. Obviously, you're talking about different assets, but there is protection there. I'm not saying there's no protection, but a lease of itself, again, dies with its contract. It doesn't run with the land, so it dies with the person who has the benefit of the lease. Is it inheritable? Well, that's a moot point. And even if it was, is it worth anything at the end of the day? So, you know, those arrangements did and do exist, but not to be recommended to people. Okay, let's deal with another popular area, and this is where certainly when I come to this part of the presentation, not necessarily from the audience, but the phone starts ringing hot afterwards, and that is use of companies to buy land. Let's be clear from the outset. If the intention of somebody, an expat, is to set up a Thai company, take a controlling interest in that company, through legitimate means for the sole purpose of buying land, it is illegal. It is against the law. And a lot of this type of development exists all over Thailand, particularly in the seaside resorts and the places where people want to retire. Now, this is when a lot of people who've entered into these schemes tend to take a gulp and think, oh my God, I'm in that scenario. My understanding, and I can't say this for certain because I'm not part of the government, but my understanding is that pre-2006, you're pretty safe. Sorry, 2016, you're pretty safe. But now, land departments are on the lookout for this. If this is something that you're told that you can do, and many people that I talk to say it's perfectly legitimate. Of course you can do it. You know, you set up this company. You know, I'll have 51% shares. You give me a few baht. I'll be a nominee for you. You set up the company. You buy the land. You're breaking the law, and you can go to jail for it. And it's becoming more and more difficult now because the land departments are wary of it. So land departments will look at a company structure very carefully now. So if they think that this is a sham, it's just not going to get registered. So anybody who tells you you can do it, forget about it. It's against the law. Where companies can legitimately purchase land, other than for commercial purposes, I'm talking about dwellings at the moment, is if they're a trading company. So if you're a company that's trading, you're manufacturing goods and you're selling them outside Thailand and you're paying your taxes in Thailand and so on, and one of the expat directors wants a home to live in, perfectly legitimate. The company can purchase property, the director can live in it, but the director has to pay rent to the company. It may not be a commercial rent, but he has to do it because the sole purpose isn't to get around the law, it's just a convenience for one of the executive staff. That's perfectly legal. You can do that. But certainly in terms of, and I hear it all the time, but so-and-so told me that I can set up a company to buy this land to build this villa. Well, so-and-so is wrong. And for those people who have entered into these schemes before, well, are they safe? The only time they're ever going to know the answer to that question is when they come to sell. That's the only time it's going to come to the forefront. And from what I'm told, if it happened pre-2016 and you were hoodwinked, the government are going to be fairly lenient on you. But if it happens, you know, since 2016, you've been warned and you're going to get your fingers burnt if you go for one of those arrangements. And the same thing very much applies to nominees, where you will get perhaps a friend. I'm not suggesting that it's all underhand stuff. It could be a good friend who says, "Look, come on, I live in Phuket. There's a plot next to me. I'll buy it for you. You build a house on it. It's all right. Nobody's going to know about it." And the chances are nobody will know about it until you come to sell. And then the problem can arise. And again, land departments throughout Thailand are becoming wise to this. The law is being enforced, and it's all very well saying, well, I can buy it, but if you can't register it, it's not worth a jot. So you have to be very careful. Land titles, well, land titles are, again, in themselves a whole subject area. But generally speaking, it's important to have a chanote, which is a land deed, which is produced at the end of the registration period. And then after that, a book, yellow book, blue book, different categories, which show that you actually inhabit the property and so on and so forth. And they can become very important when it comes to selling later on, because there are taxes payable on sale, and for that matter, taxes payable by the purchaser and fees, and it can be quite an expensive exercise. So let's just go through that. Generally speaking, if you are buying from a developer will agree to split the registration fee with you. It's 2% of value, so you'll pay 1% each. The developer will pay 1%, you will pay 1%. If you're buying from a private individual, that's not necessarily going to be the case, so that needs to be ironed out in the negotiation. Who's going to pay the fee? Because it's no small fee. It's the difference between 1% and 2%. So that needs to be looked at right at the outset. As I said, the transfer fee total is 2%. Now, there is payable in Thailand by the seller if you sell within a period of 5 years. There is specific business tax, and that is 3.3% of the value of the property. Now, that's something that a lot of people get caught out in and suddenly realise that you know, this is something they hadn't contemplated when they bought the property. So, generally speaking, if you're buying long term, it's nothing to worry about. If you're thinking of, well, I'll buy this property and see how it goes, then you really need to be staying there 5 years, otherwise you're going to get stung. If specific business tax is payable, then you're exempt from stamp duty, but if it isn't, you pay stamp duty of 0.5%. And in certain circumstances, there's also a payment of withholding tax of 1%. So in the worst case scenario, you're looking at what, 6.3% when you're selling a house if you haven't got things agreed and organised properly. If you happen to have an investment property where it is purely for commercial use, it's rented out or used for some commercial purpose like storage or just general investment, then there's a tax rate of 12.5% at the moment, and the government is actually looking at that at the moment. That may change, but at the moment it's 12.5%. Okay, well that brings me pretty much to the close. About 50 minutes, I think. Yeah, I was told an hour was my limit. There's much more I could talk about, but I think it's probably better if I deal with the gaps in conversation with you rather than stand here and lecture about it.
Ladies and gentlemen, Gav can take questions from the audience.